Will you recover your legal costs? Which is a question every client will ask. And the short answer is there is a risk that you won't. The general rule in litigation is that the successful party to proceedings will recover all or part of its costs. However, there's always a litigation risk, and ultimately it will be in the hands of the judge whether or not a party recovers their cost. There are, though, three points to make on this to bear in mind when thinking about costs and the risk in recovering them or not. Firstly is what the court refers to as its track, and that is how your matter is allocated and managed. If it's a monetary claim and you're claiming for up to £10,000, the court will allocate it probably to what's called the small claims track. You no doubt will have heard of the small claims court. Claims up to £10,000 on the small claims track are designed to be dealt with quickly and effectively, typically over a period of not more than 3 months. The process on them is cut down, and one feature of the track is that parties generally don't recover any costs. So there is immediately a question to ask yourself there. If you're going to be putting legal costs into a matter of up to £10,000, you need to bear in mind the economy of doing so, because the only costs you will recover are likely to be the court fee. A claim, again, if it's a monetary claim of between 10 and 25,000, the court will likely allocate it as what they call their fast track. Now these are middle of the road claims, and there is a far greater scope for a party to recover costs if they're successful. But even on this track, there are restrictions. For example, if it goes to a trial, there are a limited amount of costs a party can recover on the monies it spends attending at and preparing for the trial itself. Claims above 25,000 or more complex claims are treated on the court's multi-track. Now, multi-track claims tend to be more complex. The procedure is more, there are more stages to comply with. So rather than 3 months on the small track, a typical multi-track claim may last 18 months to 2 years. It's more expensive, but there's greater scope to recover your costs. So knowing how the court will manage your claim is important in understanding the scope for recovering costs, and therefore what it's reasonable for you to spend on the claim perhaps in the first place. The second point is whether there have been any offers made between the parties. The court provides for offers made can be taken into account in assessing whether or not it's right and fair that a party should be able to recover their costs. For example, if you're claiming against somebody who owes you money, and either before or during proceedings they offer you half the money that you say that they owe you, but you reject that because you feel they should pay you everything. If, when the matter finally goes to trial, the judge determines that you were correct, but that you were only correct insofar as half the money should be paid to you, the court might say that it was wrong of you to reject the offer because the offer wasn't any better than you did at trial. And in a situation like that, the court may decide to penalise you on costs because all the costs incurred from the making of the offer and you not having accepted it to trial perhaps shouldn't have been incurred. So understanding the impact of any offers made is fundamental to appreciating the risk in not recovering any costs. And finally, the court will always consider conduct and proportionality. So if a party's not been seen to come to proceedings with clean hands, if they've behaved unreasonably, if they've not complied with court orders, which perhaps has had the effect of increasing the length of proceedings and incurring more costs, they're likely to be penalised, and that might be in the form of restricting any cost they can recover if they're successful. So to summarise, will you recover your legal costs? Well, there are lots of factors to consider and lots to bear in mind in understanding the economy and merits of even bringing a claim. How the court manage your claim will be important. Whether offers are made and rejected may also play a role, and how the parties conduct themselves. As we move forward, the costs recoverable may well also be restricted by a fixed cost regime.